Hi everyone, in this week's dispatch we are focusing on disability discrimination and a particular piece of protection for employees against unfavourable treatment in the workplace. So this is where the employer treats an employee unfavourably because of something which arises in consequence of B's disability. So something that is caused by the disability itself. Now, one example might be a disabled employee has a significant amount of sickness absence. The employer decides to issue a warning, and the employee says, well, that warning is unfavourable treatment. It's only being given because of something that has arisen in consequence of my disability, i.e. the absence. There is a justification defence, so if the employer can show that the treatment, potentially the unfavourable treatment, is a proportionate means of achieving a legitimate aim, they will succeed in defending a claim. So we have a case that's just gone through the Employment Appeals Tribunal involving the employer, the General Optical Council, who employed Mr. McQueen. Mr. McQueen suffered from dyslexia, Asperger's syndrome, he had some hearing loss and neurodiversity, and that did cause him some difficulties with interactions in the workplace. Occupational health were regularly consulted. They concluded that in situations of stress, anxiety and conflict, Mr. McQueen could exhibit aggressive behaviour, use inappropriate speech, and behave in quite a rude manner. Now, on a couple of occasions in the workplace, Mr. McQueen's behaviour was described as a meltdown. He had meltdowns in the office. On one case, challenging an instruction from his senior colleague in a rude and disrespectful manner. He was aggressive and used inappropriate body language. As a result of that, occupational health was engaged, and the company actually changed the way that they interacted with him and gave him instructions. So they used email instructions instead. There was then a second confrontation which caused the manager to break down in tears. There were conflicts over job descriptions, failure to follow instructions, disputes over appraisals. He would regularly stand up at his desk and speak loudly to colleagues. He was asked not to do so because it was disruptive, and he ignored it. He was issued with a written warning in respect of some of that behaviour, and then had a performance warning in addition. He then brought tribunal claims alleging that those sanctions which were applied were unfavourable treatment arising in consequence of his disability. Essentially, he said, well, I have conditions which are protected by the Equality Act. They cause me to act in a certain way, which I can't help. I get aggressive, I get inappropriate, etc., etc. And I shouldn't be disciplined, I shouldn't be subject to unfavourable treatment as a result. Now, interestingly, the tribunal reviewed all of the medical evidence, and they concluded that the need not to be approached in a confrontational manner or to stand up and speak loudly at the desk. They concluded that those behaviours did not arise from disability. So his decision to be confrontational with staff, his decision to shout loudly from his desk, were actually behaviours exhibited not in consequence of the disability, but simply because he resented his manager and didn't want to take instructions. So there were various findings of fact that were made, and quite a brave decision, I think, not only for the employer to decide to discipline when they had medical evidence to support some mannerisms arising from his condition, but also brave of the tribunal to separate that conduct out from other behaviour which clearly was a consequence of his condition. Now, the decision was appealed. It went to the Employment Appeals Tribunal. Whilst they did criticise the logic that the tribunal used to reach the decision, they did agree that it was absolutely right for the tribunal to conclude that the behaviours which led to the warning were independent of his condition. The test that they suggested was adopted going forward were to ask, what are the disabilities? What are the effects of those disabilities? What unfavourable treatment is alleged and proved? And was that unfavourable treatment because of an effect or effects of the disabilities? So it's a helpful piece of case law that examines unfavourable treatment. It's not automatically the case that if somebody has a condition under the Equality Act and commits an act of misconduct that may be linked to the condition, that we can't do anything about it. One thing that wasn't examined in this case, because it didn't actually need to get to that part of the test, was whether the decision, even if it was discrimination, even if it was unfavourable treatment arising from disability, was that decision justified? So was the warning a proportionate means of achieving a legitimate aim? Personally, I think the company would have succeeded in justifying that warning. Even if he couldn't control his condition, the fact that the line manager was reduced to tears and they'd already made adjustments such as emailing instructions leads me to suggest that it was reasonable to issue a warning in the circumstances. So, tricky area of law. If you do need any further assistance on this issue or indeed any other employment matters, do get in touch. Visit the website chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.